Yes, I'm firing it up now. You'll start right at 7:30.
Okay. Greetings in the precious name of Jesus, and welcome to another Theological Third Thursday. This month, we are having a wonderful discussion on legal considerations for clergy. We want to thank God for our Bishop Gregory Hargrave. He's our general president, and he has allowed us to come on with this great topic. And we're blessed tonight to have attorney Ian Courts. He is a member of Jerusalem United Holy Church of America in Reedsville, North Carolina, where his pastor is Bishop Mary Jackson. He also has worked in Philadelphia, Pennsylvania as an attorney, and he is presently working now in Raleigh, North Carolina. And we're so happy to have him. He currently serves as an assistant attorney general for the Department of Prosecutions and Law Enforcement. And he is well versed, and he tonight is going to present on legal considerations for clergy. We want every pastor, every minister, every trustee, church person. We invite you to join us. Call a neighbor, call a friend, and just let them know that Attorney Ian Court is presenting tonight. At this time, I'm going to turn it over to Attorney Courts.
Thank you, Dr. Gilmore, and hello and welcome to everybody. I know the title says Legal Considerations for Clergy, but as Dr. Gilmore shared with us, it's really more extensive than that. It's pretty much legal considerations for anyone within the church or just anyone in general who may find themselves as the subject of a criminal investigation, at fear of criminal investigation or indictment, or who's just going through a civil process or a lawsuit. So what I'm sharing with you today is just a general overview, a brief summary of some of the considerations you should have. The United States as a whole and many Western, and when I use the term Western countries, I'm talking about countries that fall within either the British Anglosphere as well as some of the Western part of Europe and many countries that adopt that legal tradition and culture. Um, you see a very litigious society. You see a society where people emphasize the importance of our courts, the importance of litigation, and the importance of individual rights as defined under the Constitution. And so, even though we're people of the book, we're people of faith, we still do live in this country, in this world, and in the laws that are constructed for this world. So some of the things we're going to be looking at are how we identify resources for pastors in an ever litigious world. We're going to articulate tools clergy may use to address potential legal issues that may arise, discuss the use of restorative justice in the pulpit and the courtroom, communicate ways the clergy can prevent spiritual abuse, encourage the clergy to have a balanced, legally sound way to address emotional health while addressing potential legal challenges. Legal challenges can be stressful, but we don't want to lose our cool and get ourselves in any more trouble. What should Christian leaders understand about the legal process when a church or a pastor is under investigation or is involved in litigation? So I want to do a few things. First, I want to dispel the myth of investigation. If a person is under an investigation, it does not necessarily mean that that person in the end is going to be indicted, convicted, or subject to any type of liability. An investigation is essentially an inquiry. It's the process by which our system allows a prosecutor, a law enforcement officer, a judge, or whoever, depending on the jurisdiction, to begin to gather the facts. What's going on? One, what's the issue? Two, what are the facts that support that issue? And three, do we have enough facts to support future litigation, an indictment, which is a formal allegation that is brought about from an indicting grand jury, or do we have to let this person go, have to dismiss that? So you have certain rights under an investigation. Well, litigation is the process past an investigation. It's the adversarial process in the courtroom. It's the process of determining what facts support what contention and what outcome is going to come from those facts and those contention. So just separating those two definitions and taking away some of the myth. I hear what a lot of you guys are saying. I don't want to be the subject of any investigation or litigation. I get that, neither do I. But this is just helping people understand the process. So what is the first thing you do if you find yourself subject to an investigation or litigation? Let's say there's some allegations in the church where they're claiming that the pastor misappropriated funds, or there's a claim of some type of sexual abuse or something. God forbid any of that is going on in our churches, but let's say it happens. We're living in an ever litigious world. And again, an investigation or litigation does not necessarily mean that someone actually did those things that are being alleged, or may even get to the litigation process, but it's just the formal process of determining what the next steps are. So if you find yourself in an investigation, a litigation, indictment, first thing you need to do is be quiet. Our mouths not only get us in trouble from a spiritual side, from an interpersonal side, but it can actually get you in trouble from a litigation side. I know we've all heard it in shows. If you watch a lot of CSI, if you watch a lot of Law and Order, you hear, I have the right to remain silent. You do. Where is that right found? In the Fifth Amendment. So a little bit of history about the Fifth Amendment. The United States at the time of the Constitution had just fought a Revolutionary War with the British Crown. Under the British system, Englishmen had certain rights that were derived from the Magna Carta, which was a document where the aristocratic nobles of England held the king bound to certain rules and policies and regulations that protected them. One thing the king couldn't do is just take lands and titles from the aristocrats without giving them the ability to be able to present evidence in what they called the king's court. Well, here in the United States, what was going on during the Revolutionary War is that a lot of Americans, or a lot of the colonists, weren't being treated like full British citizens. They weren't having those same protections that was enshrined in the parliamentary process in the Magna Carta and through what in England is called the common law. If you hear about the common law in America, it's a derivative or a descendant or extension of the British common law. So the colonies were in a state of war. They were technically in a state of rebellion. So what the British Crown did was take away certain rights that they would normally have. And so if a person was brought up on charges, if a person was alleged to have done something, they weren't brought to a court. They were military marshaled, either killed, hung, or thrown in jail. So what these founders of our country, these drafters of our Constitution, determined was that's not okay. If a person is being brought before a court, if there is a formal allegation or indictment brought against a person, that person's silence should not be used against them. So that's where you have the right to remain silent. The Fifth Amendment protects you and protects your right to not self-incriminate yourself. It protects your right to keep from saying anything or doing anything that could be used against you later on in a court of law. So that's the Fifth Amendment in its application to criminal. And I want to take a moment to explain when the Fifth Amendment rights attach to a person. Your Fifth Amendment rights attach to you at the point you have any interaction with law enforcement, whether that's a law enforcement officer approaching you to question you, hey, did you see anything unusual here? Or telling you you were just speeding, what were you doing? Or stopping you for your tail light being out to anything up to the odor or smell of marijuana. Hopefully that's not occurring with us. No judgment, but just saying your Fifth Amendment rights attach whenever you interact not only with police, but with any government official. So from a criminal standpoint, remember the easy way to remember, if I'm interacting with a government official, my Fifth Amendment rights attached to me, my right to remain silent, my right not to be subject to the use of what I'm saying against me. In a civil suit, which on the civil side is more liability and less culpability, you don't want to overplay your cards, overshow your cards. You want to be quiet because what you say can be used against you uh, based off the rules of evidence. Your words can be used against you by statement by party opponent. And what I mean by that is all of us have heard of the term hearsay, out of court statements being presented as the truth of the matter. There are certain exceptions to hearsay that apply to both criminal investigations as well as civil investigations. And anything you say in a written document, in a text message, in a Facebook DM, something you write, any and all those things can be considered statements, and they can be used against you if you are the person on the other side of that V. So it's important to just be quiet because whatever you say can expose you to further liability, and you don't want to share more than you need. The second thing you should do if you find yourself in an investigation or in the course of litigation is acquire legal counsel. It's best to do this before an investigation or litigation rather than after. You want to be proactive in avoiding some of the things that may ensnare you, some methods and practices to to limit your litigation exposure, as well as just some advice on what you should or should not do from both a civil litigation perspective as well as a criminal perspective. And I know some of this may not be as applicable to some of our members who are in the Caribbean or in some of our foreign missions, but many constitutions follow this, and there may be some rights that are analogous to this. But it's just good to know anywhere you live in the world because a lot of the world's legal systems are influenced by our system. So the Sixth Amendment enshrines your right to counsel. So you do have a Fifth Amendment right to counsel, but that right to counsel is limited only to the investigation stage of litigation. Sixth Amendment right to counsel is from the time you're formally indicted or charged all the way up through your conviction or non-conviction, or any post-conviction appeal process, or during litigation and discovery in a civil process. So the Sixth Amendment right to counsel is your ability to receive sound and sage advice about what to do, how to protect your interests, how to act in the midst of litigation. So that's important to remember when those rights attach and what that Sixth Amendment right does. I think every church should have at legal counsel on retainer. We live in an ever complex and evolving world. Members are just not suing the church because they're Christians. People are actively looking for lawsuits. They're actively looking for a pot of money. As the young people say, they're trying to get that bag, they see dollar signs. So it's important for you to have an attorney to be able to shield your risks. The attorney for the United Holy Church of America is Rhonda Kelly, who is also a minister who does a lot of the work for the church and represents the United Holy Church as an institution. But it's important for local churches to have counsel representing their interests in their own individual communities. And another thing you should do is know your rights. You have certain rights during investigation and litigation, such as access to information, transparency, discovery, which is the process by which you determine what is going to be used in litigation or not, and confidentiality. One of the important things of having an attorney is that what you share with them is protected by attorney-client privilege as well as confidentiality, meaning what you share with them cannot be shared with anyone else, whether that's in a civil context or a criminal context. And just bringing it back, because this is Theological Thursday and this is the United Holy Church of America, one of the most important things we can do is pray and maintain our spiritual center. Proverbs 21, verse 1, remember, the heart of the judge is in the hand of the king. So something to keep in mind as you're going through the process. So here are some constitutional amendments and what protections they have. We touched on a little bit of them in the last slide, but we're going to go a little bit more in depth in this slide. So I would say these are the most important amendments for anyone. Most important amendments to remember, most important amendments to hold close, most important amendments to study, because these are the amendments that protect you the most. So what people have to understand, we have a constitution that had Article 1, which defined legislative power, Article 2 defined executive power, and Article 3 that defined judicial power. But it didn't do much past that. So it articulated what Congress can do, what the president can do, I know, and what the Supreme Court can do. But it didn't say much more. The amendment process was taking some of these terms such as liberty, privileges, rights, immunities, and expanding them and applying them to the people. The amendments apply to the people of the United States, while the Constitution applies to the government. If you're taking notes or you want to just sound smart when you're talking to a lawyer, you want to write that down. The Constitution, those first 3 articles in that preamble, apply to the government, what the federal government is supposed to do, what its rights and regulations are to each other. But the amendments apply to the people. What are the people's rights under this constitutional structure? So these are not the only amendments we have, but these are some of the most important amendments you should remember. The number one is the First Amendment. It's from the First Amendment that you get the freedom of speech rights you have, so your ability to be able to say godly things as well as your ability to say some off-the-wall things. You have a freedom of speech rights. Why is that important? Well, if you live in jurisdictions or in places in the world where you don't have a free speech right, and they say you can't preach about certain things or you can't say certain things, you will appreciate that right that you have here in the United States to be able to say what you want to say, free from being thrown in jail or suffer any type of criminal liability. Now, there are some exceptions to that freedom of speech right. You can't libel someone, you can't slander someone, but even those things won't land you in jail, but it may give you an expensive bill to pay. From the First Amendment, you also have the right to assemble. When you gather in your church, when you gather for Bible study, when you go to your local YMCA, you have a freedom of assembly right. So the government can't tell you, no, we don't like that viewpoint, you can't meet. We don't like United Holy Church, United Holy Church can't meet. Now, they can set certain limitations on the time, place, and manner that you assemble, but they can't tell you you can't assemble with like-minded individuals. Why? Because of the First Amendment. Also in the First Amendment, which is something that we as Christians should appreciate, or just anyone who's a person of faith, is the free exercise clause. So your ability to be a Pentecostal and not be forced to be a Catholic person, nothing against the Catholic Church, but just saying your right to be able to exercise your religious liberty is enshrined in the First Amendment, and the government can't tell you how to worship. And why that is important is many of our states, before the founding of the Constitution and the amendments, had actual state governments. Like Maryland, the Catholic Church was the official church of Maryland. In Pennsylvania, you had Quakerism. In England, you had the Anglican Church. Well, the Free Exercise Clause says people should be able to freely worship the way they want to worship, free from government encumbrance. The Establishment Clause takes it a step further. It says the government can't establish any official religion. So the government can't say we're a national atheist body or we're a national atheist country. Everybody has to be atheists. No, the government can't prohibit the free exercise of religion, and neither can it establish a particular religion. Then the second most important amendment you should be aware of is your Fourth Amendment protections. It's really the Privacy Amendment. It's your protections against unreasonable searches and seizures. So I can't walk up in your house as an individual person and just snoop through your things. You would have a private right of action against me. I could be liable for criminal trespass, subject to a burglary felony in many states, or even a criminal trespass felony. But more importantly, the government can't bust through your front door and just take your stuff unless they have a reason. That's one of those exceptions. But what people don't understand is that Fourth Amendment protection creates a standard or a barrier that the government has to meet before it can intrude upon your things. Why was that so important? You have to remember, they just came out of a revolution, the early founders. The British Army, the Redcoats, were kicking in doors, arresting people, taking pamphlets, seizing people without due process of the law. So what our founders said is the government can't do that unless they have a reason to do so. And so that's where you get a lot of privacy rights from the Fourth Amendment and a lot of Fourth Amendment protections. That's where you get search warrants, the search warrant requirement. The standard for a search warrant is probable cause. That's why an officer can't just stop you and bust up through your car. They have to have some reasonable suspicion. Now, here again, how these rights are applied in every day, we see that as Black people, people of color, and even others. We see the limits of the words on this document, but here's the protections that you do have. The third most important amendment that protects your rights is the Fifth Amendment. Again, it's your right to remain silent, your right against self-incrimination, your right to have counsel there to represent your interests if there's any formal indictment or criminal inquiry or even civil inquiry into you. The next amendment is the Sixth Amendment, right to counsel and the right to a speedy trial. So the government can't, even if you're in trial, the government can't just extend your trial for 10 years to just find all the evidence that they can. No, you have a speedy trial right. They have to be able to try you, give you a jury of your peers, and convict you or acquit you within a reasonable amount of time. Litigation is expensive. Litigation can be long, especially in certain civil cases when dealing with monies and different interests. But when it is tied to your criminal liberty and freedom, it should be done within a reasonable amount of time. Two amendments that are not here, but I also think are important, is the Eighth Amendment, your protection against cruel and unusual punishments. The government, and that's defined differently depending on the state that you live in. Some states have no death penalty, other states do, but they say, you can't be cut with 1,000 cuts. There has to be some other measure, or you can't just be thrown in horrible prison conditions, though arguably in some cases that still goes on. You have a protection under the Eighth Amendment against cruel and unusual punishments. The 14th Amendment incorporates all those first 10 amendments to the state. So you have to remember, before the 14th Amendment, which we didn't get until after the Civil War, those first 10 amendments only applied to whether the federal government was doing something to you. The state of North Carolina, the state of Maryland, your local police department, or whoever could do what they wanted to you unless your state constitution put limitations on them. But there was no federal protection of you. Well, at the end of the Civil War, the 14th Amendment said no. These first 10 amendments are incorporated to the states, and people have equal protection under the laws and rights and liberties under the rights and liberties clauses.
Attorney Courts, we have one of our listening viewers out there sent in this question. How does social media posts come into play regarding the Fifth Amendment rights?
So as I stated earlier, and that's an excellent question to whoever raised it, and it's something for our young people to understand, and even our older people. What you publish through text, through Facebook posts, through an Instagram DM, even use of ChatGPT or Google Gemini. That's why it's important to read those privacy agreements. Whatever you publish, meaning whatever comes out of your mouth and lands on some type of paper or instrument to record what you're saying or what you said, can be used against you. So everything, every text, every email, every DM, all of that should be written with the understanding that you could potentially be subject to that could be used against you in an investigation or a litigation process. So social media post,
Yeah.
be very careful because they can be used against you. And you don't have as many protections. These protections still apply, but you kind of cede some of these protections on social media. And please, at any point, if you have a question, drop it in the chat. I do want to give the disclaimer. This is not legal advice. Though I am an attorney, I am prohibited from giving individuals legal advice due to my role as an assistant attorney general, and because I don't want to enter into an attorney-client relationship with everyone. I can't do so contractually, but I can try to point you to some general education as well as information. If you have any questions, please, this is your time to drop them, and anytime throughout this presentation. So, how can leaders maintain spiritual and emotional health while navigating legal challenges? And a disclaimer, I'm not a doctor, nor am I a psychologist, but I can give you some general tips that work for me and during my process of preparing for litigation, preparing for court, and dealing with some tense situations. I tell people, because most of my role has been as a prosecutor or a government attorney, when people see me in court, it's not necessarily always a good day for them. So I have learned some particular things, one, to kind of put people's mind at ease, but also that helps people in any circumstance throughout this process. Number one, breathe. Litigation and investigations do not mean that there will be an ultimate finding of liability or culpability. It's a process. Treat it as thus. I know that's easier said than done, but that's why you have counsel to help walk you through it. Two, seek any mental health resources that you need. It's important that you maintain your mental health during the process. Three, maintain your spiritual methods and practices. Pray, fast, whatever it is you feel that you need to help keep you grounded, do so. And then I would say four, continue to serve faithfully and honestly. You don't want to adapt or change your normal behavior during the course of litigation or investigation. You want to be as normal as possible. Litigation and investigations can truly be a long and grueling process. I don't want to paint them as any roses or flowers. It can be a long process. It can be grueling. But that's what they're designed to do. In this country, we have an adversarial system, meaning there are two sides that are fighting to get their truth heard, where fact comes from proof and proof comes what can withstand scrutiny. So in our system, facts are not always necessarily what happened, but what it can be proven and articulated within the courtroom. Hopefully that matches what actually happened. There are times it does not. I would say when you're in litigation, be clear in your expectations and in your communications with your attorney. They work for you. They're there to advise you. And so you should be clear and in your expectations and what you communicate with them and what you expect for them to communicate with you. Be clear with your members of your church. Let them know. Be honest. Don't hide the fact that there's an investigation going on. There's an audit going on. I'm in litigation. Don't hide that from your members because that could create other issues in other cases. Be clear and honest with the court, most importantly. You have a duty to be honest and integral with the court. And most importantly, if you're not honest, you can be charged with perjury, which is a felony in the state of North Carolina and in many jurisdictions. And be honest to the best you can and within the limits with the opposing side. And the golden rule, we're believers in Christ, we're holiness believers. We follow peace with all men, and we try to be integral in all that we do, even in a state of litigation. And I also say demand respect and transparency in the system. You're not just a cog. You are a player and you are an actor in the system. You have certain rights that should be respected as well. And you won't be able to read this slide. I'm so sorry for it, but I'm going to tell you what is written there and kind of give you some direction. What does restorative justice look like in a church context when a harm has occurred? I know we like to think harm doesn't occur in churches, that nothing goes on. We're living in heavenly bliss. But we're humans. Things happen. People are hurt. People are harmed. And so, what is restorative justice and what does it do? Well, restorative justice, according to the North Carolina Department of Justice, has two critical measurements. One, addressing the harm done to victims, and two, reducing future criminal activity. The restorative justice process is one that seeks to address or repair harm caused by an incident or offense and involves, to the extent possible, those who have a stake in the specific offense and to collectively identify and address harmed needs and obligations. And that comes from the 2022 Restorative Justice info sheet that you can find on the website. So essentially, what restorative justice says is there has been a harm. You can't enter into a restorative justice process without acknowledging someone, some community, some individual, someone has been harmed in some way. So the person who has inflicted that harm must recognize that, and the person who has been on the receiving end has to recognize that. Restorative practices are not below or less than coercive justice methods or more traditional criminal justice or civil justice methods, but they are equally serious. They're somber, and they're effective at curbing future violence and remedying harm. If you're going to enter into a restorative justice process, you have to be serious not only about harm has taken place, but also that you're seriously committed to not inflicting further harm and not continuing the process of harm. A restorative justice approach within the church should be the default in church discipline and in potential civil and legal disputes, especially with those who are fellow members of the body. So you should take a restorative justice approach as the first approach. However, we also have to acknowledge that restorative justice is not practicable or appropriate in all situations. All situations should not go through a restorative process. There are some situations that do need to go through a more traditional disciplinary process and legal process. If you have any questions about restorative justice practices and whether a certain situation in your church would be appropriate for a restorative justice process, consult restorative justice practitioners or host restorative justice hubs at your church for youth, elders, and community members to address any beefs, divisions, or even serious matters after consulting a lawyer or a law official. Your church can be certified as a restorative justice hub. I know in this Philadelphia, when I worked there was a process by which organizations and individuals could be restorative justice certified. And that process is pretty similar in other locations. If restorative justice is something that you want to take seriously and want to be an active practitioner and practicer of, you should look into some of those resources and really take the ministry of restoration and reconciliation to another level by actively doing that in your local church. How can boards of elders and ministry teams share responsibilities in ways that prevent abuses of power? Abuses of power and spiritual abuse are increasing causes for concern in Christian churches, as well as other religious communities. But since we are within the Christian faith, I'm going to focus there. According to the John Jay report, John Jay was the first Chief Justice of the United States of America. 81% of the victims of clergy abuse in the United States are male. We have to recognize that spiritual abuse is not, or being abused in a spiritual context, is not a feminine thing. It is something that happens routinely to both men and women. The majority of abuse victims in the United States were between the ages of 11 and 13 and 14 when the abuse commenced. So it has a particular, disparate impact on young people. And in May 2023, the Illinois Attorney General reported that since 1950, there had been more than 450 accused child sex abusers in the Catholic Church and about 2,000 victims under the age of 18. That's sobering. Sobering. It's heartbreaking. And so, what are ways that we can prevent spiritual abuse? Have clear policies and procedures in compliance with the United Holy Church Manual for church discipline, expulsion, and accountability. If there is a situation that goes on in your church, there should be clear guidelines to people of how to resolve conflict, how to resolve issues. The pastor in an organization here is not the final level of authority. We do have district board of elders. We do have a general board of elders who are tasked with church discipline, and your local church manuals should have a process for addressing abuse, as well as the process for not only escalating within the church, but to government entities outside. Include the entire church, especially voting members and the youth, in the process of debating and deciding on accountability methods. Even if later you have a committee that actually creates the policy based on the input of the congregation. In addressing abuse and preventing abuses of power, it's a responsibility that's not only shared by the pastor and the ministers and the elders, or even the official board or the deacons board. It's shared throughout the entire congregation. The entire congregation should be involved in creating those accountability metrics and methods. Even if you do have a specific group who creates church policy, they should be doing that based on the input of the entire congregation. Aside from the pastor, there should not be one person accountability structures. Authority, meaning who can make a decision, can be vertical, meaning top down. But responsibility must be horizontal and it must be evenly distributed throughout the entire church. And another way to prevent spiritual abuse is encouraging retirement, replacements, mentorship, training, and appreciation. And so what I mean by that is people shouldn't be in positions the entire life. You shouldn't be the chairman of the deacon board until you die. You shouldn't be the pastor's chief intercessor until you die. You shouldn't be the youth director when you're 85. But also, when a person does retire, we should honor and appreciate their wisdom, include them in the process, seek out their wisdom, seek out their dialogue, and mentor. If you're in a process or you're in a place where you are in a position, you should always be looking toward mentorship and effective training. Training is so important. We can get used to doing things a certain way. Things change, approaches change, and it's important to stay on top of your craft.
Okay, another question. If we could go back to that slide.
Yes.
Another listener sent in this question. What are some considerations that ministers should keep in mind when providing support to those navigating the criminal justice system, particularly regarding whether there are any privileges for communication?
So I think that's a great question. I would say from a ministerial perspective, chaplains have the most protection, pastors second. And why I say that as the law legally recognizes certain chaplains and they have certain rights that are similar to an attorney-client confidentiality and privilege rights, as well as pastors. It's not to the same extent and level of severity like an attorney. If you share something with an attorney literally cannot share that with anyone else. If you share something with a pastor, and generally they have to keep it quiet, as well as a chaplain, unless you're going to hurt someone else or yourself. Ministers can support people who are going through the process by finding resources for them, helping people navigate, supporting people. In the state of North Carolina, as well as in other courts across the jurisdiction, I practiced in both Pennsylvania and in North Carolina. The courts are open. You don't really have to have a case to be able to go and sit with somebody in court. You can go and sit with them. There's also certain programs through district attorneys' offices and courts where you can be victim advocates, or if someone is harmed, you can be there to advocate for them. You can be advocates for juvenile defendants and for people who are also accused. It doesn't only have to be your church member or family member. If you feel like you're called to a ministry of reconciliation and restorative justice, there are avenues for you to put that from a religious output to more of a civil and legal output. So those are some ways to be there aside from just praying for people, fasting for people. You can actually put some legs on that faith. I hope that helps. And there's more resources there. Because of time, I can't give you everything that you can do. but excellent question. What policies should every church have in place to ensure ethical accountability? Number one, ensure that any and all policies comply with the Word of God, but that's not enough. Make sure that your policies comply with the United Holy Church Manual. We are a member of a church organization that is incorporated, which means it is a legally recognized entity. Every church manual should comply with the United Holy Church General Manual. If there is some provision in your manual that's contradictory, your church is standing in some shaky legal territory, as well as out of alignment with the structure of the church. Aside from the Word of God, the supreme law of the United Holy Church is the United Holy Church Manual. Regularly review your local church bylaws, your church practices to ensure they have clear channels of discipline, accountability, and procedural soundness. So if you do have all churches should have local bylaws, local manuals, and practices that are published for members to kind of know like how to govern certain church business, what a deacon means in your local church, what certain responsibilities, what does it mean to be a trustee, an official board member, all those to be articulated, but again, sure that those comply with the manual, but also encourage and engage everyone in the local church in the creation of those policies and procedures. Engage both civil and legal voices within your community and in the educational aspect of your church. So what I mean by that is host town halls, host community dialogues, host listening sessions, have your local district attorney or sheriff or the local criminal and family law bars. And what I mean by that criminal and family law bar is like the legal bar, the attorneys who practice in those areas come and speak. Invite judges and legislators to host town halls at your church to address concerns and not politics. So we are a 501c3 organization. We can't necessarily endorse political candidates, but we can talk about legal issues. We can talk about issues that impact real people. Another way to ensure ethical accountability is to dilute responsibility, but have a clear line of accountability. So there's not just one person who's responsible for everything, but we do have a clear line of accountability when certain things need to be escalated higher. I would say contact Attorney Kelly if you have any questions regarding just the United Church structure, or hire local church counsel to address any legal questions prior to an IRS audit, a state audit, investigation, or litigation. Should the church be conducting criminal background checks? Yes. We don't live in a time where you can just say, we come this far by faith, whosoever will come. No, I'm sorry, because you would get any and everything. And then there's also the potential for certain liabilities. And again, we don't want to further harm. We want to reduce harm in our local churches and congregations. For all licensed and ordained clergy and church officers, you should definitely be doing background checks. Anyone that's going to call themselves a minister, anyone that's going to call themselves a trustee or an officer of your church, you should conduct a background check. These positions are recognized by legal courts as being agents of the religious institutions that they are a part of, and thus they can legally bind or cause liability for their actions. Your church is an entity. Whether your local church is incorporated or not, it's recognized as an extension of the United Church via our Articles of Incorporation. And so you can be subject to liability for actions from your ministers, your elders, your board of deacons, your board of trustees. So you need to do background checks. And people are not honest, unfortunately. Now, what you do with that information, how you weigh that information, is your discretion, but weigh that and consult legal counsel if you need to on the liability part. If any person is being involved or interacting with children, they should be vetted and have a background check and drug test done before an offer or appointment and regularly after that appointment to ensure that they are continuously suitable. So it's not enough to do a background check before a person is appointed. you should be doing background checks and random drug tests while they're there. There are certain requirements and responsibilities that you should look at, and that's why you should consult your local law on those things and have a local attorney. But to be safe, especially when they're dealing with children or they're dealing with any type of money or they have a fiduciary role, I don't think people realize when you say you're a trustee of the church, you're legally bound for any incurrences or liabilities from your local church. If your local church is sued, you're on for that as a trustee or a member of the official board. So anyone who's going to serve on your trustee and official board, have worked with any of your monies, your stewards, they should also have background checks done and regular background checks while they're serving. Unfortunately, a person may be a certain way at first. Life happens to people, things come up. If a person has any type of embezzlement, obtaining false property by false pretenses, anything that would impugn their integrity or their honesty, that's something you should weigh. I'm not telling you what you should do or shouldn't do. There are certain things you should weigh. And again, we're a church, so it's not like we're a bank or we're a any other institution. We believe in restoration. We believe in people being healed, set free, and delivered. But we have to be aware that who we license, who we put out in front or in the back, can incur liability for our church. So we are wrapping up and coming to the end of this Theological Thursday. Here are some resources for people in the state of North Carolina. You can reach out to the North Carolina Department of Justice, the Public Protection Division for any type of consumer or civil rights issues, digital safety, or the criminal division if you think there's criminal activity going on. Every state has a Department of Justice who does pretty similar things. You have to look at your particular state's website for their Department of Justice or Attorney General's office. They all do similar things. Their issue areas are legal issues, accountability, questions of law. If there is a police brutality incident that occurred or police misconduct incident, they can handle those things. The Southern Coalition for many of our churches that are in the South, the Southern Coalition for Social Justice. If you have an environmental justice issue, which might mean zoning laws or the local city council is raising property taxes in a way that's unjust, they can look into those things. Criminal justice reform, voting rights. That's their website. North Carolina Council of Churches is there. Connect Church for our rural churches. Any of your local NAACP organizations are great resources. And the North Carolina Auditor's Office is seeking for churches to reach out to them for any audits of church finances that may be appropriate for that. But again, before reaching out to any of these organizations, you should have your own legal counsel to protect your interests from a legal standpoint. And thank you. And that's my presentation for this Theological Thursday. But if there are any questions or comments in the chat, I'll be happy at this time to address those.
Well, we don't have any more questions in our chat at this time, but I want to thank you, Attorney Courts, for coming on and for working with the Education Department like you do. You are indeed a blessing. You also are an instructor for our leadership training program, and he has a wonderful class that he teaches. So those of you that have not been in the leadership training program, I ask you and I offer you to please join us next year as we carry on that program, because we have some dynamic instructors in our great church, the United Holy Church of America. And I want to thank you for tuning in. And on the behalf of our Christian Education Chairperson, Dr. Gloria Oguga, I'm Dr. Gail Gilmore. I am the Christian Education Director and the entire Education Department. We want to thank you for all that you do to support this department. and may heaven smile upon you is our prayer. And we'll see you next month. We'll have Dr. Valencia Clark, medical doctor. She will be on with us for next month. God bless you and have a wonderful evening.
Good night.
Good night.